Jurisprudence Discussion Group. It was the first in-person session of 2022, and that's going to be my first in-person session since March 2020. So it's really exciting to be back again with the old ones and with the young ones as well, with JDG. Before we start the session proper, just mention that we show keen, please join us for some drinks and food in the butchery under video call, just to enjoy being together again. It's all the more delight to be here today, since we are welcoming Cécile Laborde, Professor of Political Theory in Nuffield College in the Politics Department. Cécile has been writing many articles, in addition to that, 2 big books you may have probably read, Liberalism's Religion in 2017 and Critical Republicanism in 2008. Today she's going to tell us about legal rights, well, rights to wrong and legal toleration. Thank you very much for accepting our invitation and for your great paper, and you have about 30 minutes.
Great, thanks. Thanks very much, Cécile. It's great to be here. Thanks for having me. So my topic is exemptions from general laws. So let me start with 2 basic intuitions, which I illustrate with examples. So we rightly accommodate practices that do not unjustly harm anyone, though they might generate costs for others. So for example, think of workplace regulations. They should make room for the wearing of religious signs and symbols, as well as for dietary accommodations and so forth. By contrast, we should not accommodate religious demands that violate the rights of others. For example, a law forcing parents to provide their children with appropriate medical care, including life-saving blood transfusions, if necessary, might well burden, say, Jehovah's Witnesses, but I think it should be enforced on them because of the compelling healthcare interest at stake. Or consider what in the US is called public accommodation laws, which requires businesses such as restaurants and pharmacies to serve all comers with no discrimination on ground of race, gender, or sexuality. So those who are religiously motivated to deny service to LGBTQ citizens have no grounds for exemption. And these are 2 examples. So from the perspective I speak from, broadly speaking, liberal justice, wearing a religious dress or symbol is a morally indifferent or morally permissive practice, whereas denying children a life-saving procedure or denying some citizens access to public accommodations are, I would say, morally abhorrent practices. But in this talk, I want to focus on a class of intermediate cases between the morally permissible and the morally abhorrent. And I want to call them morally ambivalent cases. So consider the following practices, which are exempted or tolerated in liberal democracies, even though they contradict legal norms protecting gender equality, non-discrimination on grounds of sexuality, or the protection of vulnerable persons. So it's a bit of a random list. It's just to pull on intuitions here. So the practice of male-only priesthood is common in many churches. Evangelical businesses have declined to provide artistic services, cakes and photographs at same-sex weddings. The circumcision of young boys is prevalent and tolerated in Muslim and Jewish communities. Not all morally ambivalent practices are religious, of course. For example, think of men-only private clubs in the UK. So morally ambivalent practices are practices that cannot easily be classified either as indifferent or abhorrent. Perhaps it's because they appeal to conflicting moral intuitions, or we are uncertain as to whether they violate rights, or perhaps they're the subject of disagreement between reasonable people. For now, I just want to assume an intuitive grasp of moral ambivalence, and I further assume that there is a non-empty set of morally ambivalent practices. So I won't say any more about what goes into the set. You can basically plug in practice you find most intuitive. The rest of the talk doesn't hinge on that. So the question I want to ask is this: what is the appropriate response of the liberal democratic state to morally ambivalent practices? And I want to explore the possibility that such practices may be legally permitted, yet categorized as legal wrongs. So it is this space, which I call legal toleration, that I seek to locate. So legal toleration models what some theorists in other contexts have called a right to do wrong, which has a similar paradoxical structure. So there are two parts to the full article. Those of you who read it, it's quite long. So in the first section, I set out the conceptual structure of legal toleration. And in the second section, I explore the normative justifiability of deploying legal toleration to exempt morally ambivalent practices from general laws. So today, I'll just focus on the first part of the article. I'm happy to take questions on the rest. So I just want to sketch the conceptual structure of legal toleration, because, well, partly because this is the part where I'm most in need of the help of legal theorists. Because the paper started with what I thought was a good intuition, but I probably would not have pursued it had I realized I would be sucked into the rabbit hole of the theory of law, which is quite an intimidating place if, like me, you're not a lawyer. So I'm basically interested in whether there is a coherent theory of law that underpins my musings. I'm not entirely sure there is, but you can tell me. Okay, so I first clarify the general notion of a moral right to do moral wrong before zooming on the more difficult case of a legal right to do legal wrong. Okay, so if fying, so let's take any practice or action to call it fy. So if fying is wrongful, can there be a right to fy? So the expression sounds paradoxical because there is a troubling semantic identity between the noun right and the adjective right, yet they connote distinct notions. The noun, having a right, protects sets of options, whereas the adjective, doing or being right, serves to guide choices between these options. So plainly, having a right to fy does not entail that fy is the right thing to do. So I might have a right to get married, but it doesn't mean that getting married is the right thing for me to do. So rights protect sets of permissible options, but the difficult task is to explain whether they can also protect options that are wrongful and therefore impermissible. So to identify the conceptual space of rights to do wrong, I drew on Hoffel's distinction between claim rights and liberty rights. So liberty rights to fy entail that we have no duty not to fy. Claim rights are claims against others interfering with our fying. Ordinarily, claim rights are accompanied by liberty rights. So if I have a claim right to get married, I'm also at liberty to get married or not to get married. But because the two categories capture different types of entitlement, the category of claim right without liberty right opens the possibility of a right to do wrong. A right to do wrong is a right against being interfered with once doing something that is wrong. So it's a claim right, not a liberty right. So rights to do wrong on that view correlate with duties of others, duties not to coercively obstruct one's wrongdoing. And when you think of that, they are a familiar feature of our normative landscape. We have rights against the obstructing interference of others when we act in myriad impermissible ways. Use freedom of speech to convey hate, certainly in the US, join a racist party, refuse to donate to charity, lie to our friends, cheat on our spouses. To be sure, some of these rights are explained by the fact that law and morality pertain to different normative orders. So when we say that people have a right to commit the wrong of hate speech, we simply mean that they have a right, a legal right to do a moral wrong. And this sentence is not paradoxical because it involves a shift within the domain of reasons. Clearly not all moral wrongs should be legally prohibited. That applies to lying to your friend and cheating on your spouse, etc. But I want to focus on the more difficult and more paradoxical case of rights to do wrong within the same domain of reasons. So plainly, the fact that I have a legal right to join a racist party doesn't exhaust the question of whether I have a moral right to do so. So can I hold a moral right to do something morally wrongful? But again, it seems that I can, because again, my moral right is only a claim right against certain types of interference from others. It doesn't bear on the rightness, validity, or permissibility of what I ought to do. So the fact that an action is wrong doesn't ipso facto give a reason to others permissibly to obstruct it. It may be, for example, that respect for my autonomy entails that I'm left free to make moral mistakes for the benefit of my moral education, for example. So moral rights to do moral wrongs, then, are at least intuitively plausible, and I will leave it there just as being intuitively plausible. More doubtful, I think, is whether it is possible as a mere matter of conceptual possibility to hold a legal right to do legal wrong. So patently, I cannot hold both a legal right to file and a legal duty not to file, assuming legal duties are uniformly enforceable. So by contrast to the case of moral duties, there is no such thing as legal autonomy. There's no discretion as to whether one's legal duties are discharged or are subjected to the blunt edge of legal sanction. So this thesis, the enforceability of law thesis, is endorsed, as far as I can tell, by a broad spectrum of scholars with otherwise contrasting theories of law. So you find it is held both by positivist defenders of versions of the command theory of law, but also by, in a different way, by Dworkinian's advocates of the judicial enforceability of law. It seems to me, however, that the enforceability of law thesis is too narrow. So the fact that law must be generally enforceable if a legal system is to subsist does not entail that legal enforceability is the marker of every single law. And more generally, the force of law cannot be reduced to its coercive effect. So state action and law interfere with actions in myriad ways that fall short of legal enforcement. So Hart famously argued that enforceability is not the chief guarantor of compliance with the law. Socialization, acceptance of authority, social pressure, as well as what he called the internal point of view, ensure compliance as effectively. Larry Sager, contra Dworkin, has also shown that though some rights are under-enforced, they still count as proper rights. So not all legal duties are paired with mechanisms of legal enforcement. Consider, for example, I think Raz also uses that example, the obligations of senior officials to carry out the duties of their office. So the possibility of the non-enforceability of law opens a logical space for legal rights to do legal wrong. There's only one academic paper on this subject, the legal rights to do legal wrong, and that's by Ori Harstein. And the rights he identifies as being legal rights to do legal wrongs are various statutes of immunity. So cases where the official status or the special circumstances of a person grant her immunity from prosecution. So consider, for example, diplomatic immunity. It's a classical example that he takes. I mean, I don't think that works for reasons I'll explain in a minute, but that's the example he takes. So think of diplomatic immunity. So diplomats who commit a crime in their host country have a claim against state officials of that country that they're not prosecuted, not to be prosecuted. But they have no claim against others interfering with a legally prohibited action, right? And their actions can generate secondary legal effects, for example, the payment of civil damages to victims. And Hallstein suggests that the structure of the right, so we have a non-enforceable duty, we have a residual legal wrong, and we have alternative sanctions. So this package, this structure, is what makes immunity cases paradigms of legal rights to do legal wrong. So what do I think of this? Well, so I think he has correctly identified the structure of legal rights to do legal wrong, but I think he is wrong, he errs in thinking that the immunities he describes are such rights. So let me explain. First then, I think Hallstein is mistaken to construe cases such as diplomatic immunity as rights to do wrong. Because other agents, public or private, can lawfully interfere with the diplomat's wrongdoing. So the diplomat really is under a legal duty not to do wrong. So what she holds is merely a narrow right against prosecution of wrongdoing by a host state. But this right is too narrow to count as a right to do wrong, especially given how easy it is for a home state to waive the immunity, so a special quirk of transnational arrangements. However, Hallstein has, I think, correctly identified the structure of legal rights to do wrong. First, he intimates, and I think he's right there, he intimates that these rights correlate with what I like to call bifurcated rights and duties on the part of the state. So bifurcation implies that the wrong is not annulled. It correlates with specific rights and perhaps duties of intervention by official authorities. So in the case of diplomatic immunity, the host state has no right to prosecute on criminal grounds, but it can pursue the wrongdoer for civil damage. So that's the bifurcation I have in mind. Second, I think Hallstein is also correct to intimate that rights to do wrong accrue to certain people only, in virtue of their special position or status. So these rights, I shall argue, are indeed best interpreted as tailored, selected exceptions from general rules. So I now want to set out an alternative account of non-enforceable legal duties which mirrors the structure of Hallstein's explication of rights to do wrong, but which proposes a different account of the bifurcation, different account of the bifurcated duties they correlate with. So here's the proposal, which I call legal toleration. So a legal right to do legal wrong entails two things. Bifurcation entails, one, a claim right against the legal sanctions that normally attach to the wrongdoing, such as prosecution, and two, no claim right against other state-imposed sanctions, such as expressive sanctions. And I'll say more about this, but just to grasp the initial plausibility of this suggestion, let me return just for a moment to moral rights to do moral wrongs, because they have a similar structure. They too have a bifurcated structure. So to see this, consider how such rights, so rights to do wrong, how they differ from rights to do what is permissible, to rights to do what is right, or permissible. So moral rights to do what is permissible merely correlate with duties of non-obstruction. By contrast, moral rights to do what is impermissible warrant additional reactive duties, such as the expression of disapprobation. So to illustrate, if I have a right to join a racist party, so an action which intuitively is wrong, right? If I have a right to join a racist party, I'm talking morally, Others are under a duty not to stop me from doing so. But if joining such a party is wrong, if I'm not at liberty to do it, then others have a right, perhaps a duty, to criticize, reprimand, or ostracize me. They would wrong me if they coercively obstructed my flying, but they do not wrong me if they attempt to talk me out of it. So rights to do wrong, therefore, seem to supervene on a distinction between obstructing interference on the one hand and other forms of interference with actions, such as disapprobation on the other. Because disapprobation wouldn't be warranted in the case of right to do right. So legal rights to do legal wrongs, coming back to my core case, I suggest they rely on a structurally similar bifurcation. So the legal right blocks a special kind of interference, that's legal prohibition, but the residual presence of the legal wrong justifies other forms of interference, disapprobation by state and official authorities. So if I have a right to fine, then the state may not prohibit my fine, but it may sanction it by official disapprobation. That's the thought. So legal rights to do wrong entail the concomitant deployment of the bifurcated powers of the state on different dangers. What I mean by bifurcated, I mean prohibitive and expressive. So the proposed legal toleration takes the form of a rule and exception as follows. So we have a rule and we have an exception to the rule. So the rule is the state generally disapproves of and prohibits fine. And the exception is the state disapproves of but does not prohibit fine by agent X. So let me just unpack this a bit. So the rule makes it clear that the state generally considers fine to be legally as well as morally wrongful. I'll only focus on cases of legal wrongs that are also moral wrongs. So fine is the subject of a general prohibition. Yet the exception allows that a class of agents, call them X, have a right to fine because of their special status position. For example, they might be churches or other expressive associations. So in contrast to the immunity cases canvassed by Hestein, X's right against state legal prosecution is secure. Right? That's the difference with the diplomat's case. So X have a claim right to fine. State officials would act unlawfully if they prosecuted X for fine, and X can enlist state officials to prevent third parties from obstructing their fine. However, fine by X is subjected to other state-backed sanctions, which are called expressive sanctions. So these can include speech by officials and representatives, as well as things such as the withdrawal of funding or subsidy. For example, the state may withdraw charitable status from organizations whose practices conflict with egalitarian norms and principles, thereby expressing official disapprobation of them. Okay, so a natural objection here is that it's unclear in what sense X are committing a legal wrong. Can this be the case absent legal sanctions? So let me suggest that it can for two reasons. First, it seems to me still the case that fine remains a public wrong subjected to official expressive sanctions. So here I draw on expressive theories of state action, whereby the state can constitute legal wrongs in a variety of ways, which include legal regulation as well as non-legal sanctions. For example, public authorities sometimes introduce shaming penalties as alternative sanctions to legal imprisonment. Or they might engage in counter-speech against hate speech. So the state might use its powers as a speaker, as spender, as educator to sanction those organizations that use rights of freedom of speech to communicate views that are incompatible with free and equal citizenship. And such expressive sanctions are functionally equivalent to legal penalties, in the sense that they fulfill the same functions as prohibition. They're designed to blame wrongdoers or to deter wrongful actions, whichever your theory of punishment is. So official disapprobation, admonition, or censure can be as freedom-limiting as legal prohibition. Right? It's not inconceivable, for example, that a religious group, if given a choice, might actually prefer to pay a legal fine as a penalty for gender discrimination, say, rather than being subjected to public condemnation and the shame of that. Second, the second reason why fine remains a legal wrong is because there's a presumption of legal prohibition of the contested action. So it's crucial to the structure of the right as I construe it. The legal duty is generally enforced on the majority of the population. So only selected individuals or groups have the right to violate an otherwise enforced legal duty. So they still commit a residual legal wrong, both because the wrong is generally subjected to legal prohibition and because, in their case, it is subjected to official state disapprobation. Okay, so assuming this bifurcation between prohibition and disapprobation is plausible, it seems that it raises a further question. Right? So you might be thinking, well, if prohibition and disapprobation are functionally equivalent, then it's no longer clear in what sense X have a right to do what others may not do. It's no longer clear in what sense, sorry, let me start again. So X are differentially sanctioned, but in what sense is the sanction they are subjected to an attenuated sanction, which will have to be the case for the right to kick in. More specifically, in what sense are they exempted from the normal duties set up by the rule? And I think we can answer this objection in two ways. First, we can note that while prohibition and disapprobation are functionally equivalent in the sense that they fulfill similar aims, retribution, deterrence, etc., it still remains the case that state legal prohibition with its assorted mechanisms of fines and in extremis imprisonment is uniquely coercive. So prohibition, I think, is more coercive than expressive disapprobation. So why? Well, state coercion decisively removes the option of fine from the set of available options, while disapprobation merely raises the cost of fine. So X are not prohibited from fine, but if they fine, they become liable to non-legal sanctions. So at this point, you might object as follows. You might say, well, legal coercion in itself doesn't, strictly speaking, remove the option of fine. It simply attaches a distinct cost to fine. So the cost of the threat of legal sanction is the cost. And so I may have exaggerated the difference between legal and expressive sanctions. But fortunately, I think, fortunately for me anyway, we do not need to settle the knotty question of the relationship between law and coercion, because I think we can answer the objection in a second, more direct way. It seems to me that the objection misses the distinctive structure of legal toleration. So X, who fine, are subjected to state disapprobation. Non-X, who fine, are subjected both to disapprobation and prohibition. So So to illustrate, a private firm which is found guilty of gender discrimination will suffer both the injury of the legal penalty and the insult of state-backed official discrimination. By contrast, a religious organization that commits the same wrong is only subjected to disapprobation. So whatever your views about whether expressive sanctions can be as coercive as legal sanctions, it is plainly the case, I think, that on a simple additive view, you might call it, the combined effect of expressive and legal sanctions is more coercive than the effect of either of them taken singly. So X's are exempted from a prohibition that falls on non-X's. So they have, in this sense, a legal right to do legal wrong. And what the right secures is the non-enforceability of a public prohibition on a specific set of people. That's what it does. So I think this hope establishes at least the conceptual plausibility of legal rights to do legal wrongs. Whether they are ever normatively justifiable is a separate question that are addressed in the second part of the paper. And here I distinguish three types of justification for such rights. Some pertaining appeal to integrity, others appeal to uncertainty, and the third appeal to reasonable disagreement about the moral wrongfulness of the action. And I raise questions about all of them, and I end up on a qualified skeptical note, I think, about the permissibility of granting exemptions as rights to do wrong.